I should welcome everybody here today to this webinar. I welcome all of our attendees and I also welcome our speakers. My name is Olawuyi. I currently sit as the Vice Chair of the British Nigeria Law Forum and practice as a commercial and property barrister from a chambers here in London called Five Paper. This webinar on this Thursday evening of the 1st of July 2021 is on the important decision of the UK Supreme Court in the Okpabi and Royal Dutch Shell PLC case handed down in February of this year. We hope that by attending this webinar, that you will be able to gain an insight into the implications of the decision and the facts surrounding the case for, firstly, pollution in the Niger Delta, secondly, global corporate governance, civil justice in Nigeria, and lastly, international litigation. The webinar has been organized by the British Nigeria Law Forum with the assistance of its keen supporters. Just a short word on the BNLF before I hand over. We are a vibrant professional organization, and we are recognized by leading legal professional bodies, both in the UK and in Nigeria. Those include the Nigerian Bar Association, the Solicitors Regulation Authority here in the UK, and the Law Society here in the UK, and also a number of leading law firms in both jurisdictions and chambers in both jurisdictions. The organization is currently chaired by Jennifer Obaseki, and we are made up of practicing lawyers and students in the UK and in Nigeria. And our principal aim is to act as a vehicle by which lawyers and other interested parties from both jurisdictions can communicate with each other to promote legal ideals, as well as foster mutually beneficial relationships, thereby creating business, networking, and educational opportunities for our members in both jurisdictions. In order to achieve those objectives, we operate through a number of subdivisions, which all members are, of course, welcome to join and participate in the running of. Briefly, these include the Business Law Network, a BNLF Junior Lawyers Division, a Family Law Network, a Criminal Law Network, and a Women's Network, and a soon-to-be established Property Law Network. Information about how to join the BNLF can be found on our website, but we will be posting some of that information using the chat function during the course of this webinar. The event, as I've said, is being supported by some of our avid supporters, including the Criminal Justice Advisory Group and Femoda Jurist Limited. Your hosts this evening will be myself and Babatunde Akinyoju, a former chair of the British Nigeria Law Forum. Mr. Akinyoju specializes in criminal, family, and civil litigation in a career spanning over 30 years as a justice's legal advisor here in the UK at Her Majesty's Courts and Tribunal Services. A short word on the program. I will shortly hand over to Mr. Akinyoju, who will introduce our excellent panel of speakers before they share their unique perspectives on the issues arising from the case with us. There will be some time for a question and answer at the end of the webinar, so I invite all of you to make use of the Q&A function just at the bottom of your screen to ask questions, which I will then put to the panelists at the appropriate time. Some housekeeping. Please note that the webinar is being recorded. We will make it available on the BNLF's website and YouTube channel, where you can also view some of our previous webinar videos, should you wish to watch it again, and where you can also share those videos and this one if a friend or a colleague has been unable to attend. On that note, I shall hand over to Mr. Akinyoju.
Yes, that's the first thing I always find out in court. Thank you, Ololade. And yes, welcome everyone to this seminar. Apologies again for the slight delay. We did start early, but we have had a few challenges with the technology. Before I introduce the speakers, I'd just like to spend a minute to talk about the people who really are the subject matter of this case that ended up at the UK Supreme Court. So they are known collectively as the Ogonis, and they comprise roughly 2 million people located in the southeastern district of Rivers State of Nigeria. Geographically, they are based along the coast of the Gulf of Guinea, east of Port Harcourt, which is the Rivers State capital. Now, according to oral tradition, the Ogoni people migrated from really central West Africa to the Atlantic coast, eventually making their way to eastern Niger Delta. And according to linguist K. Williamson, the Ogonis can be placed in the Niger Delta as far back as 15 BC. So which makes them, in fact, one of the oldest settlers in the Niger Delta region. They are known as an agricultural and fishing society. However, the most important commodity that comes out of their ground is oil. So this is, of course, the essence of tonight's session. So if I move swiftly now to our first speaker, Stephen Bilko. Steve Bilko is a solicitor at Leigh, and he specializes in international human rights and environmental law. Steve has particular experience of business and human rights cases against British parent companies and has worked on complex litigation, developing the law of parent company liability before the Supreme Court. Steve acts for the Ogale and Bile communities in this Okpabi and Shell case, as well as another case involving the Bodo community in their environmental claims against Shell. Steve also acts for claimants in high-profile corporate accountability and human rights cases involving the extractive industry. So over to you, Steve. Thank you.
Thank you very much, Babs. So I'm just going to try and share my screen. Just a second, how do I do that? Here we go. Can you just confirm you've got my screen there, please, Babs? So yeah, firstly, thanks very much to you, Babs and Ololade, and to the BNLF for inviting me to speak today. My name is Stephen Bilko, and as you were saying, Babs, I represent the Ogale and Bile communities in their cases against Shell. And it's a privilege to speak on their behalf about these environmental issues today. I'm sorry to anyone who might have any allegiance or sympathy towards Shell. As it will become quite clear, I don't have a great deal of sympathy towards them at the moment. I'm uniquely placed in my representation of the communities to give you some background about them and the oil pollution that has devastated their lives over the last well, I mean, for Ogale, it's up to 30 years. But before that, I thought I would quickly just explain how the cases that we in Leigh International Department run work. So our work, the international department at Leigh work focuses mainly on cases against mining companies. Usually around Africa, which I think is probably a legacy of colonialism, most of the issues that those mines cause. And we sue the companies on the basis that they're domiciled in the UK, and also that their operations, even when the operations are abroad, are generally controlled to some extent from a London headquarters. When we do that, we try and join a foreign subsidiary to the case in the UK, but it's not a necessary element. We sometimes just sue the parent company, leaving the foreign subsidiary out of it, if we think that is possible sometimes. So, as I'm sure you're all aware, Shell's operations in Nigeria date back to the 50s, and now the infrastructure that they have is crumbling. A huge amount of it hasn't been updated or maintained over many years, and oil has been leaking out over Ogoniland, but also a wider area of the Niger Delta for decades now. And in 2011, there was the United Nations Environmental Programme conducted a study. The study focused on Ogoniland, and the report's conclusions said that the Ogoni people have been living with chronic and dangerous oil pollution for a very long time, and will do throughout their lives. And they also condemned the environmental practices of the multinational companies that are operating there. So in that context, the first case that we, Leigh, were instructed on in Nigeria was brought by the Bodo community. This here is a picture of Pastor Christian, who is a client of ours from Bodo. He was a member of Amnesty International when the oil spills occurred, and he's also a fisherman who had a fish farm on the banks of the creeks in Bodo. And in 2008, there was a massive oil spill of half a million barrels of oil. It's estimated that spilled onto Pastor Christian's fish farms, but also all over Bodo. During the litigation of that case, it was estimated that there were 1,000 hectares of mangrove forest destroyed. But Shell, as compensation, offered a few bags of rice to the community. And so Pastor Christian came to us with Amnesty International and asked if there was something that we could do through the courts in the UK. Yeah, as I say, there were very large oil spills in Bodo, and the people of Bodo were, and still are, reliant on the creeks for fish for their income, but also just to eat. And so the local economy was completely destroyed by the oil spills. When we first started the case, we joined Royal Dutch Shell and SPDC, the Nigerian subsidiary to the case. For whatever reason, Royal Dutch Shell actually kind of sacrificed SPDC to the UK jurisdiction. So SPDC submitted to the jurisdiction, meaning we didn't need to go through the jurisdictional battle that we went through on the Okpabi case, and that resulted in a settlement in early 2015 of $55 million to 15,600 clients, and that money was split between each of them evenly. We all set up bank accounts for them, and the money was sent to each person individually. On top of that case, so there was a case for compensation, but on top of that, there is an extant claim for cleanup of the oil spills. So we're trying to compel Shell to clean up the oil spills. That case is stayed so that the community can participate in a mediation process to force Shell to clean up the oil. It's taken them 13 years so far, and the cleanup that has happened up to now is simply not good enough. But there is an ongoing cleanup there, which I believe is the only cleanup that's happening other than the high prep process. I don't know whether anyone's aware of that, but that's a government process. So after the successful Bodo case, the Bilko community instructed us. We were instructed by about 2,000 clients from the Bilko community, but there's probably more people there than we're instructed by at the moment. The Bilko community is an island off. It's about 30-40 minutes on a boat from Port Harcourt. It's not actually in Ogoniland, it's just outside, but it's still in Rivers State. But because of their situation on an island, they're almost completely reliant on fishing. So oil spills are there that we think probably happened in around 2013. Have been absolutely devastating for the community. We've had satellite imagery done of the community. It's quite difficult to see from this picture, but the dark areas here are areas where mangroves have died, and as far as we're aware, it's the largest area of mangrove loss as a result of an oil spill anywhere in the world. Our expert has estimated that it's 13,000 hectares. So that's 13 times the size of the damage in Bodo. And this is a picture I took from the water next to the island. When you arrive there, it's pretty bleak. There's nothing green as far as you can see when you get there. Everything's dead. There's no wildlife and no fish, no birds around, and the trees are all just stumps, as you can see. So the spills there have been particularly devastating. The other case in the Okpabi decision is on behalf of the Agale community. So the Agale community is about 40,000 people, and as opposed to the Bilko community, where there's been a few isolated and devastating spills, in the Agale community, there's been consistent spills onto the land and into the rivers over the last 30 years or so. So because Agale is within Ogoniland, the UNEP team did testing in the community. In the groundwater, they found levels of pollution that were 4,500 times the level at which Nigerian regulations say intervention should have happened. So there should have been a cleanup. And in one well within the community, the levels are 14,000 times that level. So the levels of pollution are quite staggering in the Agale community. As a result of the levels of pollution, there, Shell started to provide drinking water to the community. However, after a few weeks after that was implemented, the provision of water just stopped. And so as a result, the community is reliant on bottled water. And if they can't afford that, which the majority can't, they're still having to drink contaminated water. The health effects of that are at the moment unknown, but there's many complaints from the community. So this is a picture of a sign next to the creek in Agale. It tells people not to drink the water, to eat the fish, or to swim. And there's another one next to one of the main water wells in the community. So yeah, as I say, people there are having to either buy bottled water, or they're having to drink contaminated water there. So why are these cases being brought internationally? For me, and I'm sure many people would agree, that there's a slightly uncomfortable situation in which communities in the Niger Delta are having to seek justice in the UK. It's far from ideal having to do so. For us as lawyers as well, I mean, things are quite difficult running a case from the other side of the world. Logistics are difficult, and communications with the clients are difficult. But the reasons that our clients give for instructing us are threefold. The first is access to justice in Nigeria. I'll speak more about that in a moment. The second is our clients feel aggrieved that Shell's profits are sent to its shareholders in the UK and around the world, but in the UK, that's where the money is made, and that's where decisions are made. And the externalities of all of those decisions are left on the shores of their communities, and they're left to deal with the consequences. So they want to hold Shell accountable for that. The final thing that they say is that they want to hold Shell accountable to the standards that they would operate if they were operating in Europe. They say that Shell would never operate that way if they were operating in Europe. So onto the access to justice arguments, which are probably the main motivation behind bringing cases in the UK. There clearly are lots of Nigerian lawyers listening today. And if you disagree with any of these points, I'd be delighted to hear about that, because it would mean that there would be better prospects of cases like these cases being brought in Nigeria. But as part of the litigation on our client's behalf, we often have to argue that access to justice in Nigeria means that, problems with access to justice in Nigeria means that cases like the Okpabi case would be impossible in Nigeria. And maybe this is changing, but the evidence that we collected to make those arguments was that cases involving oil pollution against multinational companies in Nigeria take more than 20 years to reach. Some cases have taken 40 years. One of the main reasons is that the companies continually appeal decisions within cases with interlocutory hearing after interlocutory hearing, and the courts don't seem to have a great deal of power to prevent those things causing delays. Another problem is that the clients find it difficult to get funding for the cases, and lawyers find it difficult to get funding in order to be able to compete against the might that is Shell, and they can out-resource anyone. And finally, sometimes in cases the communities are so desperate to receive compensation that they might just accept derisory offers of compensation from the companies. So those are the reasons why our clients want to bring cases in the UK. I'll just leave you quickly with the words of King Okpabi, the king of the Igala community, from after the Court of Appeal decision. He said, "Shall underestimate us if they think this judgment will affect our resolve. There is no hope of justice in the Nigerian courts. We still very much believe in the British justice system, and so we are going to appeal this decision." It's been several years since he said that, so I'd be interested to hear if King Okpabi's views still ring true. Thanks very much.
Thank you very much, Steve. I think you gave a full history of the case in terms of your involvement as solicitor for the claimants, but also the historical perspective, which would be familiar to, like you say, the lawyers at this forum who practice in Nigeria, and also other claimants or residents who are affected by pollution and other environmental issues. And I think actually talking about pollution and the environment, that takes us nicely into my next speaker, Professor Olawuyi. I hope I can see his image.
Yes, I'm here. Thank you very much.
Good evening. Good evening. Just bear with me and let me just introduce you. Damilola Olawuyi is an international lawyer, professor of law, arbitrator, author, and policy consultant with expertise in petroleum, energy, and environmental law. He is the Deputy Vice Chancellor at Babalola University, Ado-Ekiti. He is also Director of the Institute for Oil, Gas, Energy, Environment, and Sustainable Development at that university. He is also Professor of Petroleum and Environmental Law at the Ahmad bin Khalifa University, Doha, where he teaches energy and environmental law courses. Professor Olawuyi is a barrister and solicitor of the Alberta Bar and a senior advocate of Nigeria. So thank you, and over to you, sir.
Thank you very much for that very kind introduction. And I bring you compliments and greetings from Abuja in Nigeria. I should say very warm congratulations and thank you to the British Nigeria Law Forum for giving us this wonderful opportunity to talk about the Opabi case and how we think the decision might influence the jurisprudence of environmental law in Nigeria. I think I very much enjoyed the introduction by Steve, talking about how the case came about and all of that, which was, and I will tell you right away that I agree with all of your submissions about access to environmental justice in Nigeria, which can be quite non-existent at times. I would discuss in my own presentation what I think this case would add, whether it will change much on the ground, and how I think it might influence how we view environmental law going forward. So I will give a little bit of background about the evolving conceptualization of corporate responsibility for the environment, which is, as Steve mentioned, it is now increasingly clear that business enterprises operating in developing countries will now be held accountable, and that is something that is that has been reflected in many countries, not just in the United Kingdom. You have France, you have Switzerland, you have a lot of other jurisdictions emphasizing this whole business and human rights obligations. So, and I think this case has just added to a growing, I would say, a growing list of recognition across the world. So I'm going to talk about how, the unique contributions of this case and the work of Steve and his colleagues. And I would give some remarks about what I think will be the way forward in terms of corporate responsibility for the environment in Nigeria. Like I mentioned, the last few years has witnessed, a clear recognition by, in international law that environmental protection is a human rights issue, and that businesses like Shell are major drivers of environmental harm and its impact. and like Steve mentioned, the 2011 report of the United Nations made it very clear that the environment of the Niger Delta area is so damaged that some of the impacts may be irreversible. And even when for areas of the ecosystem that are reversible, it will take up to 30 years of cleanup for that to be done. So we're speaking of years of environmental injustice. And you have two types that we've seen over the last few years. You have the direct failure to reduce the impact of gas flaring, oil spillage, and the likes, which was what was at play in the Okpabi case. But we've also had increasingly efforts to address environmental problems. Like you say, you want to address climate change and you are planting trees. You want to address climate change and you are confiscating people's lands for CDM projects, for these emission reduction schemes. So we've seen the indirect aspect of these human rights problems on the rise as well. And I've addressed some of these issues in my recent publication with Cambridge University Press, talking about how we now have not just one type of pollution, the direct one, but we now have a rise in indirect pollution as well, especially when you have the violation of indigenous rights and the likes in the Niger Delta. So what we then see, like Steve mentioned, is that over the last few years, there have been different attempts to resolve these issues. First, there's been dialogue. In the early days, there was dialogue. Then later, when dialogue did not work, especially with the, you will all recall when Nigeria's former dictator, General Sani Abacha, decided to take the life of Ken Saro-Wiwa, who was leading those dialogue, but I wouldn't go into the political aspect of what happened. But of course, as a result of the breakdown of that dialogue approach, of course, the militancy became a common thing in the Niger Delta area. That did not lead to any result, Then, of course, folks began to think of legislative reform. Basically, issues relating to oil and gas pollution in Nigeria are well covered in EGASPIN, which is the environmental guidelines for the petroleum industry. But you find out a lot of gaps. Just recently, I was asked to review EGASPIN by the UN, and I came to the conclusion that EGASPIN is as weak a document when it comes to environmental protection. Then you have NESRA, which is supposed to be the environmental law in Nigeria, but the environmental law directly excludes the oil and gas sector. It says, well, the environmental protection in this law may not include the oil and gas sector. So you see all sort of things, and you have the petroleum industry bill. We've got the good news over the last 24 hours that may become law eventually. But this has been a bill it has been a bill for over 20 years, if I'm correct now. So for many years, there's been hope that there could be some significant legislative reform to iron out some of these issues that the Niger Delta people will like to see. And we hope that the petroleum industry bill, which may now become law, may eventually address some of this lopsidedness that we've seen over the last years. Then you saw litigation in domestic court. And like Stephen mentioned, some of those could go for 20 to 30 years without any success. There's been delays. There's been, procedural delays. There's been issues of local standi. There's been issues of, some of the complainants dying even before their case is resolved. So due to all of these issues, many of these litigants naturally lost hope in the Nigerian judiciary. And you then saw over the last few years a rise in them going abroad to seek justice. One of the most, there's been so many of them, but one of the earliest cases that tried to approach a regional body was the SERAC case, which went directly after the federal government of Nigeria anyway, not after any oil and gas company. But again, trying to say that the Nigerian government has been colluding with oil and gas companies by not respecting environmental laws and environmental rights. That case was successful in terms of SERAC, but what they later found was that some of the recommendations of the African Commission were simply not implemented back home. So the pollution continued. And then you had, litigants going to the United States in the Kyobel case. They were not successful in the US. They went to Netherlands in the Kyobel case. They were eventually, the Netherlands court recognized that they had jurisdiction, unlike the US court. And of course, then I could go on and on, but I wouldn't repeat what Stephen already mentioned in terms of, the cases brought before the UK court. So I would say directly that the reason, as Stephen has mentioned, some of the key reasons why there's been loss of, why you've seen litigants going abroad is due to, delays, lack of transparency, at times complaints over governmental collusion with oil and gas companies, and a general feeling that the Nigerian courts do not have the wherewithal to break free from the extreme dependence on trying to please the government of the day. That has been the concern since the time of the military rule. As you know, the military rule really stifled the growth of the Nigerian judiciary, as they did with the growth of almost every aspect of the Nigerian nation. And as a result of that military approach to justice, which we all hoped that since the commencement of democratic governance in 1999, the legacy of military rule would have been whittled away and would have resulted in a more robust judiciary. Or you see that legacy is hard to break down, and you still see significant challenges with access to environmental justice, unfortunately. Now, what will the Okabi case add to what has been going on? Like I mentioned, this will not be the first time. Litigants have been increasingly going abroad. But what I think the Okabi case would add 4 things. Number one is that it will result in a floodgate of opportunities. Now litigants will know that they can actually go to the United Kingdom and be able to try to hold the parent companies responsible for the actions of their subsidiary. I think that will be one thing that will be noticeable over the next few years. The Opabi case has opened the door. It has made it clear that there is actually, as the case concluded, that there is a course of action when the parent company simply refuses to correct its subsidiary. So a parent company can no longer separate itself from the environmental misconduct of its subsidiary. That was made clear in the Okabi case. That will shape how litigants see access to justice going forward. I think it will also be a wake-up call to oil and gas companies, multinationals themselves, that with the increased recognition of this corporate obligation to environmental protection, then it's no longer an option, but a necessity for them. You can no longer say, well, we don't know what our subsidiary in Nigeria is doing. I think the case made it very clear that if there is an iota of some form of control or ability to influence what the subsidiary is doing, then you might actually be responsible for the environmental misconduct as well. I think that would be a wake-up call, a wake-up call that a lot of us environmental lawyers have been waiting for years. We've been hammering on this point with the rise of business and human rights norms in international law. We've been making this point. I've written about this extensively, but I think this case finally aligns, makes it clear that, we are not just writing, or we're not just speaking academically. It is actually possible now. I think number 3, it's a wake-up call to the Nigerian judiciary. Litigants will now sit back and say, well, win back our trust or we go abroad. And I can tell you that since this case was decided in February, just last week, we saw a court in Nigeria, very expeditious, issued 81.9 billion naira, in damages, very expeditious. And it was a shock to me that, wow, that's due. I think this is the legacy of Opabi. I think Nigerian courts now see that if you don't act fast, the litigants will simply go abroad, whether it's in Netherlands or in the United States, or is in Canada, or is in France, or in the UK. The litigants will simply go abroad. So I think, so I was very, very excited to see that, since Opabi, the decision in February, that there's been, and I can tell you just even before this case last week, I was approached by a number of communities who wanted to do the same in terms of go to the Nigerian High Court and Nigerian Federal High Court and file this sort of class action and the likes. So I think the Opabi case will put a lot of positive pressure or wake-up call really on the Nigerian judiciary to expedite its process, or otherwise litigants will just go abroad and see what justice looks like elsewhere. But I think it will be in the interest of justice. It will be in the interest of, because when you define access to justice in international law, there could be no better definition than being in your own country, in your community, and accessing justice in a timely, expeditious manner. So I think if this case will lead to a reform of how environmental justice is administered, then it will be a good legacy for the country, really. I also think this case will be a wake-up call in terms of the institutional reforms that we've been talking about. It is a shame on any country, and I did my search. I've never seen UK litigants coming to the Nigerian Federal High Court to look for justice. I've never seen US litigants or US citizens coming to the Nigerian Federal High Court to look for justice. It's a shame on a country if its own citizens no longer trust in its institutions and in its processes. So I see this case as a wake-up call to the institutions responsible both for environmental supervision and for remediation, to then begin to implement some of the existing laws and to make reforms where necessary. And like I said, in my report on EGASPIN, I made it very, very clear that transparency, accountability, institutional coordination remain very, very weak in Nigeria. And if these stuffs are not, if these institutions are not strengthened, I can go on and on why they're weak. You see issues of lack of coordination. You see different laws saying this agency will be responsible for cleanup. You see, even institutional role duplication. You see issues of, of corruption, brazen corruption. You see issues of cleanup funds being mismanaged. You see all sorts of issues. And my report, which is available online on the IUCN website, made it very, very clear that, unless these reforms are implemented, then citizens who have lived their lives breathing bad air will look for justice wherever they can find it. So I think the Okpabi case will be a wake-up call. And I've already been, I'm in Abuja at the moment because I've been in meetings, and I know that many of the institutions responsible for these reforms are aware of this case, and they want to see how some of those issues of transparency, accountability can be reformed. So, well, I think, to conclude, it is quite clear that Opabi has clarified the expectations of parent companies to ensure that their subsidiaries adopt international best practices to mitigate environmental harm in their operations. That's very clear from the case. That's the take-home message, I believe, from that case. And so, I must say a big thank you to Stephen and his colleagues for their contributions to jurisprudence in this area. I think it is also very clear from that case that many of the litigants have suffered environmental harm for many years, and they will no longer wait. They would look for justice wherever they can find it. And so time is of the essence. The current government, through the work of the hydrocarbon, the IREP, the hydrocarbon remediation, the body responsible for cleanup, is doing a lot, but I think those responses could be quite slow. And litigants will not wait for many years to get justice. So I think ongoing remediation efforts will need to proceed faster and in a more ambitious manner, such that affected communities can actually see or feel the efforts of the government, and they can be more interested to stay back at home and see their communities being returned to the status quo. I also think, providing fair, timely, and accessible environmental justice at home will instill confidence in the Nigerian judiciary and other responsible institutions. So if the Nigerian judiciary can keep up with the good work that they've done, at least with the recent judgment last week, if we can have more of that, then I think then we will be able to instill confidence in the Nigerian judiciary and in our institutions, such that citizens can actually enjoy the international law definition of access to justice, which is timely, fair, accessible, affordable, it's close to your home. That is the real meaning of access to justice. And I hope that the Nigerian judiciary will respond to the challenge thrown by Okpabi. I think multinational corporations themselves can now begin to reform their processes. There is a strong business case for them in terms of cost, reputation, and effectiveness to do so, even if Nigerian law is weak, even if Nigerian law is silent, even if Nigerian law is quiet on issues of human rights. International law is not. International law is not silent. And so whether you are operating in Nigeria or in Kenya or anywhere, I think responsible corporations must now understand that the era of artificial bifurcation between parent and subsidiary may fast be over. And so it might be in their own best interest to begin to incorporate human rights considerations in their investment analysis and management processes, such that they can avoid some of this backlash that this whole transnational litigation will bring, as I see that it will increase in frequency due to this growing emphasis on business and human rights. Those are my contributions. I want to say a big thank you again to British Nigeria Law Forum for bringing us together, and I look forward to answering any questions that you may have. Thank you very much.
Thank you very much, Professor Olawuyi. I think you have brought out a lot of points that would be of interest to future claimants. I noticed that case against Mobile, and I was pleasantly surprised myself. And I suppose I hesitated a bit because I thought, yes, it's a federal high court judgment. Would there be appeals? And as we heard from Steve, appeals can last really forever. But I think it is a step. It is a step in the right direction. And as you have said, a wake-up call to the judiciary, because when we are talking about access to justice, really, we want our communities to be able to seek justice in their local courts and not have to go, abroad, like you say, either to Europe or the US, and so forth. You also mentioned, it's a wake-up call to the multinational companies themselves. And because from a business point of view, yes, they have to react and, take action, because their bottom line is profits and, meeting the expectations of their shareholders. And of course, dealing with the regulatory environments to which they are subject, for example, in the UK. So I think that brings us to our next speaker. I wonder whether she is available, Dr. Odumosu-Ayanu.
She's very available.
Thank you. Thank you very much. All the way from Canada. Good to see you. Thank you. So let me introduce you, Ibironke Odumosu-Ayanu. Is an associate professor at the College of Law, University of Saskatchewan, Canada. I've been trying to get my tongue around that all afternoon. So prior to joining the University of Saskatchewan, she was a sessional lecturer at the Faculty of Law, University of British Columbia. I wish you had stayed there. It would have been much easier to pronounce. Dr. Odumosu-Ayanu is one of the editors of the African Yearbook of International Law. She is a member of the editorial boards of several journals, including the Business and Human Rights Journal and the Journal of African Law. She's vice chair of the Midwest Interest Group of the American Society of International Law. She has published widely, and she's co-editor of the Indigenous Industry Agreements Natural Resources and the Law, which was published by Routledge last year. So Dr. Odumosu-Ayanu will be speaking about global corporate governance as a result of Okpabi and Shell. Thank you.
Thank you very much for that kind invitation. I'll take the conversation a step further from what both my two earlier speakers have said. The UK Supreme Court's decision in Opabi and Shell has generated many interesting conversations, and our webinar this evening is one of them. I was fortunate to be one of those early conversations shortly after the decision was handed down in February. And that event was hosted by Dr. Anil Yilmaz and Dr. Tara Van Ho of the School of Law at the University of Essex. And we had the pleasure of having Matthew Renshaw of Leigh with us on that day as a panelist. Today, it is a pleasure to be joined by Steve Bilko, also from Leigh, as well as other distinguished panelists to have this conversation today. And I want to thank everyone that has gathered here to be part of this conversation today. And a special thanks goes to the British Nigeria Law Forum, as well as to Mr. Sarami and Mr. Akinyoju for putting this event together. Thank you for your dedication and for the invitation. Today, my brief remarks involve a call really to consider the broader implication of the Okpabi and Shell decision and to expand the conversation to similar cases initiated in other jurisdictions. And that's why I've called it an opportunity for broader conversations. And I think that in the wisdom of the organizers, they've outlined the panelists the way that they have. So I'm just going to take the conversation a step further. The UK Supreme Court's decision in Okpabi has received the attention that it has garnered since February because it is a groundbreaking decision. However, it is not the only case of its kind, and neither is it the first time that the highest court of a home state has found that a case may be heard against a parent company in the home state to answer claims against it for harms caused by its subsidiary abroad. Yet the case is incredibly significant, even if the Supreme Court was saying something that we've argued all along. Like Professor Olawuyi was saying, like, these are not academic conversations anymore, but it is something that academics have talked about for so long right now. I was initially going to introduce the claimants because a lot of the work that I do considers the place of the affected communities. But I think that Mr. Bilko, Steve has done a fascinating job of that. So I'll skip that part, but I'll say one thing about the claimants. The claimants that we see in the Opabi case are similar to claimants in cases of this nature. So for example, in the UK Supreme Court's decision, another one, Vendanta and Lungowe, you also had almost 2,000 members of rural farming communities in Zambia where Vendanta operated, bringing an action in the UK. So we witness these types of claimants quite often. As well, I wouldn't spend time on something that I wanted to talk about, which is also an introduction to the respondents. I think that Steve did a fantastic job of that earlier. Where I would like to start is identification of some general challenges, kind of building on the challenges that my two co-panelists have talked about so far. And it is that in spite of the somewhat favorable lens by which some courts have started to view jurisdictional issues, for example, in Okpabi, in Vendanta, for example, and even in cases regarding liability on the merits, for example, the 4 Nigerian farmers cases at the Dutch Court of Appeal, many hurdles remain for claimants seeking remedies before foreign courts for harm that they suffered in their communities. And that's why I agree with Professor Olawuyi that the best place for these claimants is in their own states, really, to seek justice in their own states. But in the absence of that happening, we have to deal with the kinds of issues that we're dealing with today. One of those general challenges is what was identified in the UN Guiding Principles on Business and Human Rights, saying that states do not really have an obligation to regulate the extraterritorial activities of businesses. One of the things that I believe that the Opabi decision and decisions similar to it contribute in this regard is that even though they're not strictly regulation, a case like Opabi provides some direction regarding when courts will assume jurisdiction. So it's helpful in that regard, even if a state does not have an international obligation to regulate these activities as of now. There's a lot of conversation around what the obligations of states may be. One of the things that the Okabi decision does is to at least provide a framework for when courts would assume jurisdiction in cases like this. Another one of those challenges is what the Supreme Court identified in Vedanta, for example. And I think it was Steve that alluded to this, where the Supreme Court was talking about issues of comity and the dangers or the risks of offending international comity, where the courts of other states assume jurisdiction in cases like this. Regardless of the merits of an argument of that nature or the side on which one lands on the argument, it is an argument that is often referenced and adopted as justification for inaction, but the UK Supreme Court, by its decisions in Opabi or a case like Vedanta, for example, seems to be moving past these jurisdictions, this justification. So we're beginning to move past some of the hurdles that have seemed to affect cases like this in the past. The main crux of my view on Opabi is that what it offers us in terms of broader conversations, like we can look beyond the case and see where it takes us with regard to similar cases around the world. So for example, how should claimants proceed in the future? Because as my co-panelists have said, these cases are not ending anytime soon. So on this slide, for example, I have examples of cases that have proceeded just from Nigeria alone, similar cases that have proceeded just from Nigeria alone, cases brought before courts in the UK, cases brought before courts in the Netherlands, cases brought before courts in the United States. So the Okpabi and Shell claimants are not alone in seeking to respond to these types of questions. So the phenomenon that led to the Okpabi and Shell case is a common occurrence, and as the first speaker, Steve Bilko, was talking about, Leigh also litigated the Bodo case before it was settled. So there are many similar claims. Few of the cases have been successful at the jurisdictional level and fewer still on the merits. Some of them have been settled. And the claims are based on a variety of arguments, generally, the Nigerian cases and the cases from elsewhere. So look, like the duty of care, as we see in Opabi, there have been cases that have been based on customary international law arguments. There are cases that have been based on the United States Alien Tort Claims Act, right? So there are many ways of approaching these cases, and claimants have been quite apt to go for whichever one they think will be successful. So as we can see, Nigerian plaintiffs have happened to file many of these cases. Most of these cases come from pollution in Nigeria's Niger Delta. There are some cases from other jurisdictions as well. These are just examples. Vedanta, for example, coming out of Zambia before the UK courts. Nefsun and Araya is a case that was decided in 2020 by the Canadian Supreme Court, where the court said that Canadian courts could assume jurisdiction for alleged harms that had been done in Eritrea. We have Chalk and Hot Bay Minerals as well from Guatemala that is before Canadian courts. There's Ramirez, Piedra, and Copa Mesa that came before Canadian courts out of Ecuador. So this is actually something that happens quite often. So the question is, how do we proceed? What is the implication of a case like Opabi for these types of cases? So as significant as the Supreme Court's decision in Okpabi on jurisdiction is, there's some general questions that remain, and Okpabi has started to answer some of those questions for UK courts. So when will a court of a home state assume jurisdiction? And that is on two sides. When would it assume jurisdiction regarding the parent company? When would it assume jurisdiction regarding the subsidiary? And Opabi tries to answer some of those questions for us. When will other foreign courts assume jurisdiction? And that's something that US courts have struggled with the Kubel cases, for example. On what basis will the courts assume jurisdiction? I've talked about the duty of care, customary international law, statutes in places like the United States. And when will parent companies really be liable for the acts or omissions of their subsidiaries? These are all questions that we're still grappling with, and cases like Opabi are beginning to answer some of those questions for us. But many challenges remain in many places. For example, there's still the forum non-convenience argument that often comes up. There are often questions about the corporate veil and corporate personality. Damilola was just saying earlier, just as he was finishing his conversation, that those corporate personality hurdles are beginning to shift with cases like Okpabi, but they still remain, even though they're beginning to shift. And as I bring this to a close, I'd like to look at some of the approaches that are being taken. As I said, one of them is the approach of the UK Supreme Court in Opabi, where the court said that the liability of parent companies in relation to the activities of their subsidiaries is not of itself a distinct category of liability in the common law of negligence. It raises no novel issues of law, and it's to be determined on ordinary general principles of the law of tort regarding the imposition of a duty of care. In the context of parent and subsidiary relationships, whether a duty of care arises depends on the extent to which and the way in which the parent availed itself of the opportunity to take over, intervene in, control, supervise, or advise the management of the relevant operations, including land use of the subsidiary. And that's quoting directly from the Supreme Court's decision in Opabi, with the Supreme Court again citing to Vedanta itself. So here it's taking an approach like, this is pretty simple. It's the duty of care. Let's consider the relationship between the subsidiary and the parent company. So we then need to start to have those types of conversations and take seriously the relationships between the parent company and the subsidiary. So we need to assess the types of control, oversight, and direction that a parent is given to its subsidiary. But beyond Opabi, as I said earlier, and this is me beginning to round this up now, the Canadian Supreme Court has also adopted an approach that was placed before it in Nefson and Araya. Here we had a split court, but the majority came to the conclusion, and I quote here, that it is not plain and obvious that corporations today enjoy a blanket exclusion under customary international law from direct liability for violations of obligatory, definable, and universal norms of international law, or indirect liability for their involvement in complicity offenses. Ultimately, for the purposes of this appeal, it is enough to conclude that breaches of customary international law or use cogents relied on by the Eritrean workers may well apply to Nefson. So the Supreme Court of Canada has adopted a customary international law approach. So that's another possibility. And the final possibility that I bring before you today is something that is beginning to crop up in the bilateral or other investment treaties that some African countries are beginning to sign. There's a big limitation in these treaties in the sense that most of these treaties are intra-African treaties. So for example, they won't help in an Okpabi and Shell kind situation, which is governed by Nigeria, UK bilateral investment treaties or Nigeria, Netherlands bilateral investment treaties. But at least we're beginning to see African states direct their minds towards these types of questions. So the ECOWAS Supplementary Act on Investment, for example, says that home states like the UK shall ensure that their legal systems provides for court actions on the merits, that people can bring actions before these courts where they seem, it's possible to do so. The Morocco-Nigeria bit is also, bilateral investment treaty is also another instrument that has taken this approach. And it says, and I quote, that investors shall be subject to civil actions for liability in the judicial process of their home state for the acts or decisions made in relation to the investment where such acts or decisions lead to significant damage, personal injuries, or loss of life in the host state. So that's really just saying what has happened in Opabi here is a possibility if you had had a bilateral investment treaty. What the cause of action would be is something entirely different, but here they're at least providing some kind of access. So all of these are ways that jurisdictions are beginning to deal with this issue. And to conclude, my point is that one of the takeaways from the Opabi decision is that it offers us the opportunity to broaden our horizons, to begin to gather stories from around the world on cases of this nature, and hopefully to begin to learn some lessons from both the successful jurisdictional claims like the Opabi case and claims on the merits, like the 4 Nigerian farmers cases before the Dutch courts, as well as those claims that were not successful. It is an opportunity to consider the implications of the decision for the relationship between parent companies and subsidiaries, for corporate governance, and for long-held views on corporate law principles that have actually hindered these types of cases in the past. Thank you.
Thank you very much, Ibironke. I think it was interesting to learn that, Okpabi and the Supreme Court is not the only case where Nigerians have sought justice. They have been to the UK, they have been to the Netherlands. And now, like you say, there are various avenues in which the courts are looking at how to introduce a nexus and assume jurisdiction, whether it's a duty of care in the negligence tort, customary international law, sometimes some legislation, as in the US. I'm also comforted that, like you say, ECOWAS is beginning to play a role in terms of maybe making the courts in what former colonial states, making them kind of responsible when there are corporations, the private corporations, are transacting business in countries like Nigeria, or even, as you say, some countries in the Caribbean. But I think that brings us to our last speaker, who would be speaking really about Nigerian justice, access to justice, really, civil justice in Nigeria. So Nancy Obinwa is deputy head of Etiaba Chambers in Port Harcourt. Her law practice spans human rights law, commercial law, and corporate law. Nancy is a skilled mediator and arbitrator, and is passionate about the welfare of women, children, and the indigent. And these are exactly the people we are talking about, because I think it's important that, there's this focus about human beings who are breathing in this toxic air every day. She is a member of the Nigerian Bar Association, the International Bar Association, and FIDA, which is the International Federation of Women Lawyers. She's a member of the Chartered Institute of Mediators. Nancy was educated at the University of Nigeria and the University of London, where she holds a Masters of Law in Commercial and Corporate Law. So Nancy, so you're going to tell us that Nigeria is ready to do its business. Thank you.
Okay. Thank you very much, Mr. Akianju, and thank you also to the British Nigeria Law Forum for this opportunity to participate and share my reflections as an advocate on this burning issue. I have heard the three speakers, and the beauty of being the fourth and last is that a good foundation has been laid, and so I'll just work on that. Mr. Bilko wasn't pretentious at all about, should I use the word disdain for the oil giant Shell? Okay, I understand that. Interestingly, I have had the opportunity to represent not Shell, but one of the oil giants. And so my reflections today is not just from the part of the community people, but as well from that other angle of the oil giants who want to make a profit, and in Nigeria as well, the Nigerian government also wanting to make the most of the resources that we have in our country. I bring warm greetings from the Niger Delta, where I practice, Port Harcourt in Nigeria. And we are here on ground and see and feel a whole lot of things concerning the degradation of the land. The degradation is real, no doubt. But the truth also is that there are sometimes some form of vandalism that goes on, some sabotage just to get the oil giants to pay compensation. If we can differentiate between what is real and what is not, then we'll be making a lot of progress. Again, it's easy to say that the justice system in Nigeria is slow, but I believe it's a common issue all over the world. Justice can sometimes be delayed, but not denied, if the parties and their lawyers are dogged enough to do their work well, to do their research, and not allow themselves to be thrown aback by some preliminary objection. The oil giants and their lawyers are well, should I say, tutored and well researched on issues that can slow down justice or even truncate it by way of preliminary objections. The degradation may be for real, but then how prepared are the lawyers to fight for that right of the indigents, of the communities? Most of the people in the communities, they are indigent. They're unable to afford good legal representation most times. And so it's also about the passion of the lawyers who understand and feel their pain to represent them, and who also must overlook issues of fees to pursue justice. The challenges which I will focus on in today's presentation, towards getting justice for communities with claims of environmental abuse, degradation, stems from many angles. The Opabi case, for example, while we rejoice today that yes, it's been established that a parent company can be held responsible, it's not automatic. It is to the degree that that parent company was actually not just de jure, but de facto controller, de facto manager, de facto authority as regards policies that were implemented that affected the communities. If one is not able to tie that, then you may be saying justice is being denied. It must be established that that parent company actually had controlling rights over the subsidiary. So it's not something, Okpabi is not something everybody should just take and run away with. Oh, whenever there is an action like this about pollution of natural resources, the waters, that, oh yes, let's just go to the UK and institute an action there. It wouldn't always work for all companies. It depends on the level of control that the parent company had over the subsidiary. Another thing we should also watch out for in instituting an action such as what we're talking about now is the issue of jurisdiction. If a court lacks the jurisdiction to entertain a matter, there is absolutely nothing that will be done in that court that would get justice for the claimant. On appeal, it will be overturned. So jurisdiction must first be sorted. For a claim that arises here in Nigeria, one can't just say, I would rely on the Opabi case and jet off to the UK to sue a parent company that is involved. On what basis are we taking that step? The laws in Nigeria make provision for where actions should be instituted. It takes more than there is a parent company in the UK and it's likely that justice will be faster there to, go to another jurisdiction to get judgments. Basic issues of the right of action, the course of action, the form of commencing an action will affect the success of that action. If lawyers are not able to do their due diligence, it shouldn't be blamed on the courts. In Mr. Bilko's presentation, we could see the slides he was showing of the degradation of evidence that have been compiled to ground a cause of action. When we fail to do our due diligence and a matter doesn't succeed in court or is struck out based on a preliminary objection by solicitors to the oil giant, we cry there is no justice in Nigeria, but that's not true. Again, while we may want to rejoice in the Opabi case, and I'm truly very glad for a case like that and what is decided, what has happened so far really is more of a procedural advantage that has been settled that, okay, yes, you can sue the parent company. But whether they have achieved their goal of compensation is still another journey. The journey so far in the Opabi case has lasted for years. And that is just to establish a triable action and to say that, yes, a parent company can be a party, but their liability hasn't been determined. So cases last long, whether here in Nigeria or anywhere else in the world. The challenges are the same. It behoves on the lawyers involved to do their due diligence and keep pushing. The Court of First Instance in the Opabi case, the next appellate court, wasn't a decision in favor of the community. If the lawyers had given up then, we wouldn't be here today rejoicing over the Opabi case. It takes a lot of doggedness, dexterity, determination to keep pushing for these communities. I heard the learned essay and also rejoice over the recent case that was decided at the Federal High Court. That was another journey of about 8 years. The Ibeno community in Uyo, a representative action by their head, the chief. And interestingly, again, they didn't bring that action in Akwa Ibom State that has a Federal High Court. For reasons best known to the solicitors, they had considered Abuja a good place to do that. Again, by the books, by our rules. An action such as that can be brought where the defendant resides. The parties in that action are Mobile, Nigeria Producing Unlimited, and Nigerian National Petroleum Company. Now, as a government parastatal with head office in Abuja, the action could be brought in Abuja. If the action were brought in Uyo, well, I wouldn't know the challenges that they had there, not to bring it there, because that was one place else they could also bring that action. But their choice to bring it to Abuja, maybe it helped in the quicker dispensation, I wouldn't know, but the outcome has justified that means. And they are well covered by the books to have done that. Otherwise, in Nigeria, in our laws, we have what is called forum shopping, which has been interpreted by the courts to mean abuse of court process. You don't go looking for a court that you think would give you judgments that you think would be more favorable to your cause of action. A preliminary objection can be brought against that and your action will be struck out. And all of this will cause the delay in justice delivery. I was fortunate to run into the solicitors that represented the Ibeno community in this matter we're discussing now last week, and even had a further phone conversation today. And I can tell you that the journey was a difficult one. Several objections were thrown at them in court, but with the due diligence that they had exercised in instituting that action, where they did it and how they prepared their processes, today it's success story. if they had not put in all they put in, it will be part of what we say justice in Nigeria drags, it's slow, and may not even be there at all. So we must be able to differentiate between when an action really does not have merit and when it is knocked out technically because the lawyers have failed to do their due diligence. The courts in Nigeria, we have vibrant courts. I am not speaking for all courts, but we can't make a generalization that Nigeria is slow, and so with Opabi case, let's all go to the UK. Again, the UK judgment is persuasive. The courts in Nigeria must not follow that precedent. My real takeaway in this Opabi matter is the fact that preliminary, the counsel for the plaintiffs was able to establish the relationship between the parent company and the subsidiary company. If it wasn't established in that way, there wouldn't be the success story that we are rejoicing in today. Moving this further, other than environmental actions, other actions as well are in representative capacity or class actions. They are not always easy and within a short lifespan. This is the characteristics of most actions that are brought either as a class action or representative action, whether in Nigeria or outside of Nigeria. The case of Dukes and Walmart stores incorporated in the USA lasted for several years. It was a class action. The plaintiff initially filed the action pro se, just as an individual, challenging gender discrimination in the workplace and how the male counterparts get to earn more. Eventually, it was expanded to include other people who had the commonality that, yes, they too have been discriminated against. From the court of first instance to the two appellate courts, it was a long journey of years, a decade. And that action still failed. Because according to the Supreme Court in the US, they were not able to establish their cause of action. So I do not think at all that it is something that is peculiar to Nigeria when it comes to a delay in justice, especially in actions of this nature, in representative capacity pertaining to environmental degradation. Another class action that went very swiftly in Nigeria was the case of Babalola and Apple Incorporated. He sued the big giants in the USA. They were served and the action was here in Nigeria, and it lasted for just about 3 years, up to the Court of Appeal. It was fast, though he did not succeed again because the court did not agree that there was commonality and that he could sue on behalf of all iPhone 6 users. But there was speed in dispensing the justice in that matter. So really, for me, it's about the preparation. It's about gathering the evidence. It's about the locus. It's about the cause of action. It's about the jurisdiction where you file, as in the territorial subject matter, because these things affect the time span, the lifespan, rather, of the action in court. It's one thing to have a good case, a meritorious case, and it's another thing to present it well. When one is unable to make a good presentation in court, which starts with the pleadings, with the evidence lined up to support every fact that has been pleaded. If we don't start it right, then the outcome, we can't blame the outcome either. So my point today really is for good preparation before setting out in courts. We don't get it right, then we should be prepared to take whatever comes at us, because we shouldn't think that the oil giants with very deep pockets will fold their arms and be watching, or quickly agree to compensate in millions of dollars or naira. They will fight back. They will always fight back, and they're very good at hiring very senior lawyers, senior advocates to defend them. So a whole lot of work is required from any solicitor who would represent a claimant in an action such as we are talking about today. For me, for example, in our firm, yes, we do have retainerships with some oil giants, but also recently, there is a matter where the community have also briefed us. I understand my time is almost up.
I was going to say, yes.
It's a balance. It's really a balance, and to follow your conscience really, and to do a good job, no matter what side of the divide that briefs you. We say we are ministers in the temple of justice. Ours is to do our job very well.
Yep.
Whichever side you are on. I think I would have to stop here now. So in conclusion, let's not just run away with the Opabi case. There must be work to be done. There is work to be done before you can rely on it. Thank you very much for the opportunity. I'm done.
Thank you very much, Nancy. And in fact, I've been looking at the comments as you have been speaking, and I think quite a number of participants agree with you. There is no alternative to good preparation, and managing the expectation of clients, of the claimants, and even of the judges. Like you say, if a good case is not presented to them, then there isn't going to be the result that the claimants expect, regardless of the harm that has been alleged. And you did touch very much on due diligence. So I think that's a salutary lesson for all of us advocates, practitioners, and so forth. I think really that takes us into the Q&A session. So I'll hand over to Ololade. Thank you.
Thank you very much, Mr. Akinjaju, and thank you to all of our panelists for the very interesting speeches you gave and sharing your perspectives with us. We've had a number of questions come in, and I think I have a couple of my own, but I'll prioritize the questions from our attendees. The first question that has been asked comes from Alexandra Fowler. I'm not sure Alexandra is still in the webinar, but it is an interesting question, and it's a question for Mr. Bilko. The question is, can you please talk a bit about the actual legal basis for the cases seeking compensation in the UK courts? Are you arguing negligence, hence a tort claim, breach of a statutory obligation, or something else? That's a question that I think is answered by briefly reading the case, but I'll leave that to you to answer, Steve.
Yeah, so the Vedanta and Okpabi decisions are quite clear in saying that there's nothing special about the law when it comes to responsibility for parent companies. It's a simple tort, and the claims are pleaded very simply in negligence. We say that the parent companies are responsible because they exercise control over the operations of the subsidiary. In each of our cases involving parent companies, the degree to which the parent company controls those operations differs. And I can't remember whether it's the Vedanta or the Okpabi decision, but anyway, one of them says that everything depends on the way in which the parent avails itself of the opportunity to intervene or to take over the management of the operations of the subsidiary. And so, I mean, because the decision itself is not a decision on the merits, it doesn't really go into how. Sorry, this is kind of answering the second question, which is addressed to me, which is what's the smoking gun in a case like this?
Please go ahead.
Because the cases are at a preliminary stage, the evidence is never really addressed in any detail. But we hope that through the Okpabi decision, claimants will be able to get over this first hurdle by using a simple negligence claim, to then get through to the process of disclosure, through which the smoking gun hopefully will exist in an email or some policy which the claimants haven't yet had access to. Sorry, I skipped ahead to the second question there. The answer to the first one is it's a simple negligence case, and in the second one, hopefully the smoking guns come from disclosure when the case is developed to the next stage.
Well, what you've said leads to what connects in my mind to something interesting that Mrs. Obinwa said while she spoke. She said, she talked about the importance of carefully gathering evidence and that it can affect the lifespan of cases in court. Did you face any special difficulties in accumulating that evidence? Because although obviously there hasn't been disclosure in the main proceedings just yet, you need a substantial amount of documents and evidence in order to be able to plead a proper case. And I'm sure the pleadings are substantial. Any thoughts on that?
So the first instance decision was really disappointing because the claimants were held to a really high standard. They were required to show evidence that, I mean, most claimants just simply shouldn't be expected to be able to provide the evidence that they're going to need to be able to prosecute or to successfully win a case at the very beginning of a case. So it took us a very long time to be able to collect the evidence that we needed. And had we not got permission to appeal both the decision of the High Court and the Court of Appeal, we never would have got the evidence that ultimately was decisive, which turned up as a result of some disclosure that Shell had given, but they gave us incomplete documents. And we were arguing to the court that we needed to see the whole of the document so that we could, you know, show what was what our case was. So yeah, significant problems, and I think as a result of the Okpabi decision, which says claimants shouldn't be expected to have all of the documents at the start of the case, that will mean claimants now are able to progress to the next stage where they can get disclosure of documents and get witness statements from employees of the company, for example.
Thank you, Steve. There is a question here from Nanette, and I think this is best directed to Professor Olawuyi. So it's coming at you, Professor. It says, host communities revert to international law due to Nigerian state failure to uphold their rights. To what extent do international norms echo with local/traditional concepts? How do we also embed culturally sensitive approaches to dealing with these cases, walking away from the traditional top-bottom importation of norms and concepts?
Well, that's a very loaded question and a brilliant one, I must say. International law is quite clear. Access to justice and the likes are well recognized in some of the core international human rights treaties. But at the end of the day, the implementation is at the domestic level. So while international law can go as far as prescribing the expectations or prescribing what countries should do, in the end, the ability to provide access to remedies at the likes will go back to the countries. And for example, you know, we've been talking, and Professor Odumosu-Ayanu talked about these old business and human rights norms, access to, you know, especially the Rugi principles and the likes. But the truth is that, you know, not all countries are implementing those norms yet. So for example, even though Nigeria is a signatory to many of the international treaties that underpin the business and human rights norms, you know, efforts have been ongoing, to put it mildly, to codify and implement those norms. So business and human rights norms are still quite missing in terms of actually putting them to domestic law and putting them into domestic practice. So what I would like to see is for governments across Africa to begin to see what other countries are doing in terms of due diligence laws, vigilance laws, like you see in France and the likes, which try to implement these international norms and give it a local slant. So the localization of international norms will depend on domestic institutions. And I would hope that Nigerian institutions can see this, the moving train and get on it as quickly as possible in terms of localizing these norms and making sure that victims of environmental harm have appropriate remedies as international law preaches.
Thank you for that. I think this question actually relates to something else well, it relates to something else you said earlier on, which I'll bring up and which connects to a question by Olaitan in the Q&A. Something you said earlier on was that, and forgive me if I did not put this as eloquently as you said it in your speech, but I think you made a suggestion that the courts, that there was some degree of concern about political influences in terms of how they carry on their business of dispensing justice. And the next question is that was that there is a sense in Nigeria that the courts, even on the weight of evidence, is refusing to rule that the parent company in the UK is responsible for the decision and direction of the Nigerian entity because of the economic importance of RDC Shell in the UK. Do you have any thoughts on that?
Well, the politicization, as you can call it, of the Nigerian judiciary has been a subject of academic interest for quite a while. And that is because right from the time of the military, you've heard judges rule and saying, my hands are tied. I know what to say, but my hands are tied. And so with the advent of democracy, we thought their hands would no longer be tied. But what we see is that, and I will be very unfair to say all judges are the same, but what we see increasingly is that there's been a continuation of the erosion of the independence of the Nigerian judiciary, and even the current government of the government of the day in Nigeria came under the flak recently when the homes of judges were raided and the likes, and judges were targeted, and they became almost in an attempt to stifle them and make them scared to perform their jobs, their duties in an independent manner. And when you have that erosion of the independence of judiciary, what you then see is that the government can easily collude with oil and gas companies and push through projects, even though the judges will otherwise not allow such projects. So it's a case of my hands are tied all over again. It's only that it's now some of us can then speak and say the hands should not be tied because we're no longer in the military, so in the military regime. So what we see is that there is a need to protect the sanctity of the Nigerian judiciary and to protect its independence. And until we achieve that independence, a lot of such delays would occur. A lot of justice, issues of justice not being served will occur, and that's the message we've been preaching. And we hope that increasingly some of the ongoing reforms to the aimed at ensuring the independence of the Nigerian judiciary, we hope those reforms will see the light of the day.
Thank you, Professor Olawuyi. I'm conscious of time. We started about 10 minutes later than originally planned. So I'll put just 2 more questions to our panelists, and so that we can wrap up without holding you all for later than we had originally envisaged. This question goes to Ms. Obinwa. I feel like it is one best directed towards you, Ms. Obinwa. And it's another question from Nanette, who asks, what would be your bet to foster / strengthen Nigerian, British, or otherwise foreign cooperation at legal practice / chambers level to support the institutional reform, strengthening the rule of law, and mainstreaming of Nigerian jurisdiction over these cases? So I direct this to you because a lot of what you talk about, it was access to justice in Nigeria. So it'd be interesting to have your perspective on that if you have any thoughts. Mrs. Obinwa, if you're speaking, we cannot hear you because you're muted.
Ololade, can you hear me?
Yes, we can hear you now.
Okay, the question is what can be done to...
Yes, let me just repeat it. It was essentially,
okay.
What would be your bet to foster or strengthen at Nigerian, British, or otherwise foreign cooperation at legal practice level, so chambers, law firm levels, at the lawyer level, essentially, to support the institutional reform, strengthening of the rule of law, and mainstreaming of jurisdiction over these cases in Nigeria? So what can lawyers do, essentially, is how I understand the question, to help?
What can they do is part of what we are doing here today.
Okay.
We must rub minds, we must exchange ideas. And when we have cases, see Steve Bilko. Steve Bilko is not Nigerian, but he has taken up this matter and he has filed it in the court in the UK. And today we are discussing it on case-by-case basis, every case on its own facts. And we should have more collaborations. We should grow in our partnerships, especially for Nigeria, where we have a whole lot of one-man practice, one-man firm. We should expand and have partnerships that will cut across the borders. And that way we can share a whole lot of knowledge and enrich our practice and the development of the law generally. That would be my answer.
Excellent. If only there were a bilateral forum in which Nigerians and British legal firms can exchange ideas. Sorry about that. I thought I'll plug in the BNLF there. Anyway, the last question I was going to put to the panelists, I think this one is really for both Stephen and perhaps some views from Ronke, Ms. Odumosu-Ayanu. And that's the question about the future of UK parent company litigation. And I want to broaden that for Ms. Odumosu-Ayanu. What do you think is the future of essentially international parent company litigation? Steve, I think you might want to cover that from a UK parent perspective and leave the rest to Ms. Odumosu-Ayanu.
Yeah, so the Okpabi case is obviously really, really helpful in terms of holding parent companies to account. From a UK perspective, because of Brexit, we now lose the benefit of European legislation, which allows cases to be automatically brought in the UK courts where a company is domiciled here. So that leaves where cases are now brought, if we can't accede to the Lugano Convention, where cases proceed against RDS, for example, the potential way that that's going to proceed in future is it will only proceed if the UK is the right forum to bring it, and so the courts revert to arguments about forum non-convenience, and in doing that, one of the questions that will be asked by the court is whether claimants can get substantial justice in Nigeria, and so there's essentially the question of how things are going to develop in Nigeria. If things are positive in Nigeria, then cases can and will proceed there. If not, cases will probably still be possible in the UK.
Thank you, Steve. Dr. Odumosu-Ayanu, do you have any thoughts on that?
Thank you for that question. I guess for me to just add a few things to what Steve Bilko has said, and I agree with his thoughts right there. Like forum non-convenience was one of the things that I mentioned. I think that a lot of the relationship between parent companies and their subsidiaries and liability in these relationships will continue to play out in the forums in which we see them playing out, like domestically. And the reason I say so is that international law for decades now has really struggled for many reasons, power, economic interests being two of them. The international law has really struggled with assigning responsibilities and liabilities to corporations. So there's been that debate that has gone on for a long time. We're beginning to see some breakthroughs happening, of course, with do I want to call norms? I don't want to call them rules. Some norms around due diligence coming up right now, and responsibilities rather than obligation. It's a deliberate choice of words right there. Responsibilities of corporations, or especially parent corporations towards subsidiaries. So that's that unwillingness, if I would say, in international circles to say that this is the responsibility of corporations, although there is some movement, there's a treaty being considered right now. But I think where the real movement is happening are these cases that we're seeing, like on a case-by-case basis, being litigated and actually attaching liability to these parent corporations. And as has been said, a case like Opabi is a case on jurisdiction, right? We're not sure yet where it's going to go on the merits. The Dutch cases is a fairly recent one that has gone in favor of the communities on the merits, but there are not so many cases like that. So a lot of work still remains to be done on these types of cases, and of course, internationally as well. Thank you.
Thank you very much. I appreciate your responses. I did promise that that would be the last question, but I'm tempted by one further one. And I think, and this one is directed towards Steve. And two people have asked a question. That's why I'm tempted by it. So we can cover two questions essentially by putting one. And it's in relation to funding. What are the, or how it's phrases, may I ask, what is the place of funding in execution of these kind of cases, especially since the affected communities are indigent?
So the cases are funded by conditional fee agreements. Essentially, the claimants don't pay anything if they lose the case. It's no win, no fee, which means the law firm funds all of the disbursements and fees while the case is running. If the lawyers are successful, then they'll get their fees from the defendant. If not, they don't get paid. So it's a risk for law firms to take on these cases, and the benefit potentially is that if they win, there's the potential to take a cut of damages if the case is successful in the end.
But I think it does speak volumes about the motivations of a firm like Leigh in taking on such a case and taking on such risks. Anyway, I think that's a great place to wrap up the webinar. I think I'm just going to pass on to Mr. Akinyoju, who's going to give some closing remarks.
Thank you, Ololade, and thank you very much to the speakers and also to the questions that have been put to them. And I think the kind of takeaway, one would have from this, a lot of issues have been raised, but the matter of education, because this is a forum of lawyers, and I think, as Nancy emphasized, the need to well, first of all, educate ourselves, keep ourselves aware of what's happening, Nigerian law, but also international law, because as we've heard from, the speakers, Ronke, Steve, Damilola, and even Nancy, international law does impact, domestic law, and of course, the claimants themselves. I think Professor Olawuyi talked about the sanctity of the judiciary, independence of the judiciary. That also is very key, not only in cases involving all gens, but really the issue of access to justice in general. And that is something that I personally am very passionate about. One person or one group that I think is missing from this panel is actually a government agency, a government representative, because look, let's face it, look, Steve could win his case and so forth, and all the other claimants and so forth, but how or when is the cleanup going to take effect and going to happen. That's what is really going to bring the change. And the person who can answer that, like I say, is a representative from the government. So, I mean, my plea is that, you know, going forward, I don't know whether there are any government representatives, you know, amongst the participants, but I think, you know, really we would need to hear from what actually those who are able to implement, you know, cleanups and protect the environment, how that is going. We've heard today that the Senate passed the PIB, the Petroleum Industry Bill. I mean, BNLF actually did a session on PIB as far back as 2013, and then it was still 5 years old. So I would be interested to know how PIB is going to address this issue, and I think the other legislation that was mentioned. On that note, I'm going to get off my soapbox. And like I say, thank very much the speakers who've given up their time. Excellent presentation. I hope you have all found it useful. So thank you very much, Stephen Bilko. Thank you very much, Professor Damilola Olawuyi. Thank you, Dr. Ibironke Odumosu-Ayanu. And thank you, Mrs. Nancy Obinwa. So on behalf of Ololade and myself, representing British Nigeria Law Forum, I wish you all a good evening. Thank you.
Thank you.
Thanks very much.
Thank you.
Thank you all.